The brief facts of the case is regarding the appellant, who was the chairperson of a non-governmental organisation, NGO, known as Bersih 2.0. Upon collecting her boarding pass for a flight to South Korea at the Kuala Lumpur International Airport, KLIA, she was stopped by the immigration authorities. She was told that there was a travel ban imposed on her. The appellant was blacklisted for 3 years, but the travel ban was lifted by the respondents only 2 days after she was stopped at KLIA. The appellant filed an action for a judicial review upon the decision of the Director General of Immigration. The decision of this case shall be stressed on the doctrine of basic structure and ouster clause, whereby both is relevant to judicial review. In the majority judgment of 4 judges decided that the doctrine of basic structure does not exist in Malaysia on the basis that the idea of basic structure of the Constitution is a mere obiter by past judges in cases such as Semeneh Jaya, Indira Gandhi and Alma Nudo. Next, it was decided that the Parliament can enact law containing an ouster clause is valid, where the judiciary must comply because the amendment of Article 121 Clause 1 of the Federal Constitution, which constrain the power of the judiciary and place it subservient to the Parliament. Regarding the ouster clause, it was held in majority that the court have always exercised supervisory jurisdiction even if there is an ouster clause in any provisions. In other words, the court can still review decision on administrative law principles. Thus, the court cannot review decision on constitutional law arguments, such as the fundamental liberties. Moving on to the minority judgment by the Chief Justice herself and 2 other judges, it was held that the doctrine of basic structure exists in Malaysia. Any attempt to prohibit judicial power, such as an ouster clause, is unconstitutional. Therefore, it was held in minority that Section 59 and Section 59A of the Immigration Act 1959 are unconstitutional.